አንዳንዶቻችን ሰምተን ይሆናል ስለ ሌክን ራሊ አክት። ይሄ ህግ በሁለቱም ኮንግረሶች በአብላጫ ድምፅ የጸደቀ በኋላ ላይ ትረምፕ የፈረመው ህግ ነው። አሁን ላይ በጣም አደገኛ የሚያደርገው የዚህ ህግ በማንኛውም ወንጀል የተጠረጠረ ሰው መፈረድ አይጠበቅበትም፣ ወይም ደግሞ ፍርድ ቤት ኮንቪክት ማድረግ አይጠበቅበትም። በሾፕሊፍቲንግ፣ በርግለሪ፣ ኤኒ ካይንድስ ኦፍ ክራይም ከተጠረጠረ አሬስት ከተደረገ ቻርጅ ከተደረገ የአይስ ኦፊሰሮች ይህን ሰውዬ አስረውት ዲፖርት የማድረግ መብት የሚሰጣቸው ህግ ነው። ሌክን ራሊ አክት አንዶክመንትድ በሆነ ሰው የተገደለች ሴትን አስመልክቶ የወጣ ህግ ነው። እንግዲህ ይህ ህግ አንፌተርድ የሆነ በጣም ሰፊ የሆነ የማስፈጸምን ኃይል ነው ለአይስ ኦፊሰሮች፣ ለኢሚግሬሽን ከስተም ኦፊሰርስ የሚሰጥ። አንድ ሰው አንቲል ፕሩቭን ጊልቲ ኢኖሰንት ተብሎ ነው ኮንሲደር የሚደረገው ማለት ነው። አሁን ላይ ግን በሌክን ራሊ አክት አንድ ሰው ከተጠረጠረ አሬስት ከተደረገ ብቻ ወንጀሉን እንደፈጸመ አድርገው በመውሰድ የአይስ ኦፊሰሮች ዲፖርት የማድረግ አቅምና የህግ ጋራንቲ ነው የሚሰጣቸው ማለት ነው። በዚህ ነው በጣም ከፍተኛ ጥንቃቄ ማድረግ የሚጠበቅብን። ለምሳሌ አንዶክመንትድ የሆኑ ሰዎች በተለይ ምንም አይነት የሾፕሊፍቲንግ፣ የበርገሪ፣ ቴፍት የሚያስጠረጥሩ ነገሮችን ወይም ደግሞ እኛን ለጥቆማ ለሰስፔሽን የሚዳርጉ ነገሮች ላይ ፈጽሞ መገኘት የለብንም ማለት ነው። በብዙ ክንድ መራቅ አለብን። አይ ስትሮንግሊ ሰጀስት በመጀመሪያ ደረጃ ምንም አይነት ሪከር እንዳይኖሩባት መጠንቀቅ፣ ከዛ ከሚዳርግ አካባቢና ኤንቫይሮንመንት መራቅ። እንደ ድንገት እንግዲህ ከሰው ጥፋት አይታጣም። ጥፋት ልንሰራ ልንሳሳት እንችላለን። ኢሚዲየትሊ ይህን ነገር እንዴት ማስተካከል፣ አደጋ ውስጥ እንዳንገባ እንዴት ማስቆም እንደምንችል ከኢሚግሬሽን ሌሮቻችን ጋር መመካከል ከኛ ይጠበቃል። ቴንክስ።
I have a deportation order. I have my I-212. It was approved and I am waiting on my 601A. If ICE detains me, will I have a right to see a judge? So here's an individual who has gone through the deportation process already. A judge made a decision on the case and you have the 212 approved and you're waiting on the 601A. Obviously, New Jersey, we would be making an argument for your release, number one, from detention, that what we would be looking to do there. I think that you would be able to have a process, an opportunity reasonably to say to ICE, it would really be to ICE, that you have a case going and that they should use their discretion to release you. That's what we would be focusing on. The judge issued that decision against you. If you're very concerned about it, obviously work with, I don't know, you may have a lawyer already. Talk to your lawyer about it, or you could talk to us one-on-one, but I would be focused on your release. Is there any chance for me to be approved for a green card if I have a 204C attached to my record? So now this 204C is a marriage fraud that is attached to his record somehow. So what we would do in your case, Mike, is we would get your records from immigration to determine whether they got it right. When they labeled your file, so to speak, as 204C or came to that determination, why did they do that? Did they get it right or did they get it wrong? Is this something that we should fight? And we've been very successful in fighting some of these 204C allegations in cases where they were only allegations. But, you know, if it's a situation where this 204C was attached to your file correctly because you were part of a marriage fraud arrangement, well, we don't defend marriage fraud at all. But believe it or not, there are some ways that individuals under our law are able to still get through in certain circumstances with this 204C. For instance, if you had gotten a 2-year green card from USCIS and then you were trying to get your 10-year green card, and during that process they discovered you got your green card through fraud. It was a fraudulent marriage, and then they deny your petition for the 10-year green card, and then they issued a notice to appear in immigration court to begin that removal process against you. Well, when that happened, you go into removal proceedings, and it's possible to ask for a waiver before the judge in immigration court, but this is very limited to individuals who had received that 2-year green card to begin with, not the general person who had never gotten a green card because their case didn't even get that far. Immigration caught the marriage fraud way before it got to the point of issuing a green card. So that's one of the ways to get over it. There are blogs out there, a lot of information out there on the 204C bar. But if you'd like to go deeper and speak with us about your background, we'd be happy to speak with you to see if there's anything that we can do to assist you, okay?
You may have heard that many USCIS officers were sworn in and deputized in order to carry out ICE functions. In other words, in order to carry out immigration enforcement or removal, right? And detention. And recently, USCIS has been posting on its public social media accounts about various individuals that they've detained at USCIS offices in conjunction with ICE. And so what I want to warn you all about is this. If you have an upcoming appointment at USCIS for whatever reason, whether it's for a fingerprint appointment, if you have an interview on an I-130, or even an adjustment of status, if you do not have a 100% clean record, in other words, you don't have any immigration violations or history, you don't have any type of bar, you don't have a removal order, you don't have any criminal history, then you will probably be okay, but you should still consult with an attorney. However, if you have anything on your record, any prior immigration history that might be complicated, any unlawful entries or re-entries specifically, possible removal orders, criminal history, I strongly suggest you consult with an attorney before attending that interview, because USCIS is detaining people at its offices and they're publicly posting about it. Additionally, we have heard through other practitioners that their clients are being detained at I-130 interviews if they have prior removal orders, or at other types of check-ins, such as fingerprints or ICE check-ins. So just take this as a warning to consult with an attorney prior to attending any interviews specifically at USCIS. Maybe you want to pay to have an attorney present there just to ensure that you are not detained. Or if you are detained, an attorney can file some type of perhaps emergency stay of removal if you have a removal order, or otherwise properly advise you.